back into session. We have one timed item left, and that's a joint meeting with the Planning Commission. So at this time, the chair of the Planning Commission is Ginger, correct? You're the chair. So I'll turn it over for you to open up the Planning Commission side, and then we'll go from there.
Okay. So I would like to bring our meeting to order at 4:05. And I believe, Darwin, I would like to defer to you about where we go from here.
Okay, so Darwin, for the Board of Commissioners, this was a requested joint meeting between the Board of Commissioners and the Planning Commission, and I believe there was some questions that would be asked of the Board of Commissioners. And I'll let you, like Ginger says, give an overview of.
So, we'll give you a little bit of history here. That I'm going to stand just tends to catch me right behind this the screen here. So, the Planning Commission has been asking for a couple of years now to talk about solar. Specifically, we've for the last 4 years been kind of open-ended on a model code update of our zoning ordinance. And going back to the solar for a second, is that the Planning Commission has asked me to get a meeting with you guys for a while to discuss topics such as, where projects should go, how much solar is enough, cumulative impacts of solar on the landscape in Lake County. And I've informed the Planning Commission over the last couple of years as well that the solar rule is changing at the state level. I've been on 2 different racks as of late, going over the solar rules and amendments to be made to those rules that currently exist on from the original rack that was set up back in 2011 that I was also on when I first came to Lake County. So the Planning Commission would, as advertised for this meeting, would like to just have a discussion about, general topics for solar, but also then specifically on their rules when it comes to land use applications, and then also on the model code update that we're going through for our exclusive farm use zones, the A1 and A2 zones, and then also the forest use zone, a resource zone. So I've got an update on that I'd like to get into as well, but what I need to do quickly, as our other meeting went longer than it should, is I want to pull up my screen here and then go to some of the emails that were sent back to us with specific questions that I may have forwarded to you guys already. I didn't. Okay, so Jim Bailey could be available by phone. I don't know if either of you individually got back to him on his last question, but he does have an email that we could pull up as well. So that's kind of where I'm seeing this going, is this the Planning Commission. I've got 4 of our 7 members here.
Could I ask a question?
Yeah.
So Travis and Jalen couldn't make it?
Yeah, they couldn't make it
Okay.
for reasons I won't get into at the moment.
That's fine. I just was curious if they were going to be able to make it at all.
Okay, so Darwin, on the zoning ordinance and the update on that, that has been brought forward over the last few years. I believe that may be something that we go through relatively fast or not. Is there new, different information? And there is 2 new board members sitting here compared to when we were that board
So
before.
yeah, for the model code itself.
Yeah.
So as Planning Commission knows, and as the board's probably aware of, is also the zoning ordinance itself is a version, largely created in the early 80s that has been had some modifications and updates, very minor, I would say, in scale. Even most recently, as probably 3 years ago with our TSP, there was a little bit of updates with that and the comprehensive plan at that time. But it hasn't had a major overhaul in which a few planners and I, back in 2014 had pushed this idea of a model code. And then the state ran with a consultant to do the model code, and we were one of 4 counties that got involved with updating our ordinance to what the state has as the current ORS and OAR language, which is the revised statute, and then also administrative rule when it comes to our exclusive zones, exclusive farm use zones and forestry zones. So that update process in 2015 hit kind of a wall. Looking at our current code, there were a few major items that we didn't anticipate having to kind of jump over these hurdles. And I'll just briefly touch on 2 of them, the most major, which would be an acreage minimum change, going from 80 acres in our agricultural designated areas, which primarily are the lowest grounds in the county. So most of the Warner Valley here, Goose Lake Valley here, and then also some areas around Silver Lake are our major areas, and there is some in the Warner Valley in the Plush area that are 80 acre minimums to date. And then there's 160 acre minimums pretty much on everything else, which is zoned rangeland. The forest is zoned 80, which is not set to change, but the state had at some point, and I don't have the correct date in front of me, but sometime between 89 and current, they changed those minimums to 160 and 320 for range designated land. So that was a major change that we didn't anticipate, and which would then also require that we send out a measure 56 notice, which lets landowners know that we're going to be changing their land uses and the availability of some of the options they've had. So that was hurdle number 1, which we weren't planned to even undertake. And then the other major hurdle is something that I've talked about with the Planning Commission a lot, and individually with board members, that we've got a comprehensive plan designation that is the baseline for how those original developers of our code envisioned the lands would be used. And so the comprehensive plan is that overarching document, which is the baseline, I guess, designated the whole county into these different designations, of which I've talked about: agricultural and rangeland. And then the model then the zoning ordinance itself would also have its own zoning layer. And when our code was written, it allowed for the comprehensive plan to be different than the zoning ordinance. So these 2 maps do not align with one another. They are different in many areas, but our zoning ordinance, which implements the comprehensive plan, allowed for it recognized these differences and allowed for them. And I give as the primary example the Anna Reservoir area in north of Summer Lake, which has the Carlin Lane, Lakeview Lane area, that subdivision, as farm residential under a comprehensive plan, but it has the zoning of A2 agriculture, which is a protected zone under state law, which then says you would have to apply certain criteria under the standard, and that standard would be a non-farm dwelling standard, and all the criteria that goes with that. And that's very different than all counties that I've ever seen and experienced, and kind of looked at other counties' ordinances. So we've got a unique situation where, since those 2 don't match up, we don't process that area and new homes under a non-farm dwelling standard. We process it as a simple zoning permit, which doesn't follow the same standards, which the state now, because of the model code, wants us to implement. I saw that as a huge problem, knowing, and I researched it, that none of those lands in that subdivision are under farm deferral, so none of them are getting any benefit from an A2 zone you know, tax break kind of situation, they're all, you know, recognized as highest and best use as a potential dwelling site. So
Is that just the area between Lakeview Lane and Sept and Garland Lane, or does that expand?
yeah, it's
beyond?
just that area. There
Just
is
that
another area which is the Emery Rosebud Acres, right? If you're
Okay.
familiar with that
Yeah.
site, east on
Same thing there.
the end of Thousand Springs Lane.
So Darwin, is this from back in the 70s when we came through and just done the soil classification? Basically, they took the map and said, well, this has soil classification, we're gonna make this A2, we're gonna do all this. And today, as development is happening, we're governed by that soils classification, even though these lands aren't used for farming. I think that's the consensus almost across the state of Oregon and eastern Oregon anyway, that happened.
Yeah.
They just sort of,
So on my map, it's up on the screens now, you're seeing, you know, this lighter shade of green here, and then the darker, which is the forestry zone. The Sycan Marsh has got some agricultural zoning out there. So this is all, this lighter is the A2 zone, and then there is some A1, like I said, around Silver Lake. So that the Anna Reservoir area, which is, you know, you can see all these platted lots designated by the black lines, and there's primarily, you know, triangles running north and south.
I see one of these spots, there's a dark green. Who's that?
That's the only one that anyone wants.
And then, so what I've switched on here is the comprehensive plan map, and it's got, you know, as I click on this, it's saying FR, which is farm residential, that's a 10-acre minimum. I mean, nowhere near the 160 and the 320 that the state wants us to go to, right? So when we talk about the zoning of an A2 agricultural zone, which is an exclusive farm use recognized zone, protected, you know, by goal 3 in a statewide planning system.
So the dilemma whenever we were working through this a few years back was, is if we update that plan that triggers all of this, in Lake County, we've been pretty much pro, make it opportunity for people to be able to develop here within reason through the planning commission, through CUPs and different things. Moving it up to the 160 and the 320, with some concerns that came forward.
Yeah, definitely. And so I threw now on the sage grouse layer, which shows you core areas designated as purple, and then out here is green. So let me take off the county zoning for a second to show you again the sage grouse layer. But when we talk about this area, for example, it's got, you know, about a third of it's within this subdivision is mapped core habitat. And according to the sage grouse rule, you cannot rezone property to like a rural residential, which this would essentially need to get to make it a stamped kind of administrative decision, not a huge non-farm dwelling application. So, you know, we've got some huge conflicts with the way the land really lays and what the actual use of the land is compared to what has been mapped as habitat. And
You're on Old Lake Road
Yeah,
now,
so-
same problem there.
yeah, same problem here, because there is comprehensive plan designated area up here that is also, farm residential, 10-acre minimums up here. And these are 20-acre lots, so technically they should be able to be partitioned as well, in half, and there could be some major issues there. I'm not gonna get into, you know, some of the big game winter range, but we get some of that in there close to it anyways too.
And so if I'm not mistaken, Darwin, I don't want to jump ahead of you, but even in the plush area with the checkerboard, BLM and our private lands, you have the overlay of the core habitat, plus you have many small parcels out there. It's not just a few places, it's different places, right?
When we ran into this specifically was down by New Pine Creek where we had
Oh, yeah.
big game, that big game
terrible
overlay. And it's a rural residential area right here.
And there's our big game map right on top of it, which,
With the cut the parcel in half.
And that's what, you know, why ordinances written and not allowing for flexibility really create ourselves up for really huge problems when we should ultimately, and our zoning ordinance is written that way, if there is a discrepancy or there's confusion as to what the map is saying, then we would have the right to interpret the map. But ODFW has a certainly who's trying, I'm not gonna speak for them, but how it's come across to me is that, you know, they're there to protect the wildlife and everything that goes along with that. But, you know, an area like this that was recognized prior to this map being adopted and you know, implemented, and then the GIS layer actually being created for it, you know, this area wasn't even discussed, and it should have been. I mean, it was a measure 56 notice sent to them saying that you're gonna lose your rights for this. I mean, to me, they would have a very strong option for a measure 37 or 49 claim, right? And so, which I'm not gonna get into, but put an asterisk next to that comment. And we can
Well, this is where all these overlays and everything, and especially with the Oregon Department of Fish and Wildlife, with their mapping, they're a non-regulatory agency. We're a regulatory agency, DEQ is a regulatory agency on land use. Whenever it comes to trying to develop any of these, then you have to go by the good science, which is biologist, which is non-regulatory agency, which really doesn't give a damn if you have any private property rights, I guess. I'm being a little bit bold, so we're running into this controversy multiple times. You as a planning commission probably see this a lot more than the board of commissioners see. But these overlays, you haven't even got into ACECs, RNAs, wilderness study areas and everything. By the time you get all those overlays for private property or even BLM to be developed, is becoming more and more limited. So whenever we was talking about opening up this plan, it was going to be even limited even more. And I'm speaking for the previous board of commissioners, working with our planning director. The reason why we at the time wasn't comfortable with going forward, moving that up to the 320 and the 160. And so that maybe was not absolutely the right decision, but the board that I worked within, I don't want to speak for this board, were pro-development within the guidelines of being able to develop within your own properties.
So to put to rest a discussion that could go on for hours on this model code update, let me just tell you that I recently spoke with the LCD, and I've sent them emails after a planning commission recommendation was given to me in June at our meeting up in Christmas Valley to change the way we process non-farm dwellings in the Christmas Valley area specifically, but also to look at other areas as well, where we would take like the Penn Phillips areas where we know that there's 5, 10, 20, 40 acre lots that have access, that are platted lots that were created in the 60s, that for some reason, when we went through and added a zoning layer to all this, we designated them all as agricultural lands, knowing that someday, essentially, those would all get taken out of, when developed, and they're all privately owned, and almost always no, adjacent neighbors the same. It's always something different. It seems like that those would then, be irrevocably committed to a non-farm use. Therefore, they would, the landscape would be changed in a way that would never go back to real agricultural use. So, knowing that a lot of those applications that come before the Plan Commission are a template.
Rubber stamp.
Yeah, rubber stamp kind of, no comments almost always from neighboring owners. Even the special interest groups don't get involved with trying to fight those. They kind of even recognize that, it's a unique situation that we've got up in the North Lake area. And so, DLCD doesn't comment on those. Nobody does, right? So is the Plan Commission's recommendation to me to change them from a Type 2 conditional use permit, which the Plan Commission would review, to a Type 1 conditional use permit that I would make the findings for, and still send out notice, still give people an opportunity. It is a land use decision recognized by the state that does allow for people to request a hearing. which all decisions made by me, that notice goes out that says, hey, this is a tentative approval, but it would have to get, a hearing if you request one. And so, that recommendation was made to me, so I sent an email back in early July after that meeting to DLC, and they just recently got back to me and said they really didn't want to comment on it, right? Because they don't want to give, the perception that they are supporting, any kind of land use situation. I won't quote you who told me that, but, DLC, wants to just, kind of let us kind of do our thing, and then when they get the notice, then they may appeal it or not. And so with the model code itself, I asked specifically, well, we've held original meetings back in 2015. The Plan Commission, in those evidentiary hearings, reviewed all the model code language that we were given, made recommendations to the Board of Commissioners with those 3 items, one of which, final one I didn't talk about was, would our ordinance, would our exclusive farm use zone still qualify for farm deferral with all the listed allowed uses that would move forward. So anyways, that recommendation was made. We then held hearings before the Board of Commissioners, and we at that time, I wanted to go to the language quickly in here, but it was recommended for adoption if we got, kind of a final go-ahead from the state on those 3 issues. And state, again, never really gave us answers or direction other than saying, well, you need to follow the code. Well, that was, again, changes that we weren't really ready to make, but we were at least ready to make some steps forward. And so after the discussion I had with the state recently, I feel that it's important that we hold a hearing, which I will get with Mel and schedule. And if the Plan Commission feels comfortable, I can re-show you those documents. But essentially, it's taking the state ordinance and adopting it into our zoning ordinance. And then at that point, we would be up to date with the minimums that the state has, which, there can be, you can always go above and be more restrictive, but this would be the baseline that we would start from. There was a lot of updates also to our conditional use section, to definitions and other things. But I will present that very quickly to the Planning Commission, and as long as I probably have your blessing, I would still want to schedule the hearing with you guys to just
So
kind of get that
Darwin,
done.
Planning Commission have new faces,
A
new
lot,
people on
almost
it.
all new faces.
So
since
before that
started.
comes to the Board of Commissioners for hearing process, it needs to be blessed by the commission as far as I'm
Yeah,
concerned.
okay, so I appreciate you saying that, and I
Well,
probably didn't give you almost enough background, again, other than I'm
They're the
not
ones
trying to
that have-
blindside the
They're the
Planning
ones that
Commission.
have to
but-
use those
Yeah,
rules
they
to
would
make
use the rules.
decisions that can be appealed to us.
So
They're
part of
the-
that, part of why it's important to have it in our code is so that the general public is aware of what the criteria is without having to go search the state code. Right, and so some planning offices have gone as far as just adopting, the state law, and they have a pretty short and sweet sentence that says in their code that, hey, we apply directly to the state law, and then they'll have it on their desk, that state law, which changes every year, right? And so people come into the county and say, hey, what can I do with my land? And here's the state law, this is what our code says, we follow that directly. There are certain types of uses that you cannot apply it directly. We apply, like the solar rule, for example, directly. We can and we should and we have to. Other uses we apply the rules directly. So in all intents and purposes, the code itself is the baseline that we're supposed to be following anyways. It's just by adopting it, then we have it in our code, which is going to be a huge undertaking to kind of reformat so that it's really an easy read instead of bits and pieces that are
Yeah.
kind of
Yeah,
throwing
it needs to be
together.
comprehensible, it needs to, it can't contradict itself.
Yeah, so, and that is a large undertaking, because when we had the consultant working for us on this, which again was nothing we paid out of pocket, the state funding, provided the consultant, Angelo Planning Group, was who did this project. They were doing this model code for multiple counties at a time, and like many projects, we get seen very little and not very quick responses, and then by the time you were starting to get into it and understand what you have, you're left with the consultant saying, all right, have a nice day, here's your document, and good luck.
Your invoice.
Yeah. So really, my angle here is to get the notice, an adoption from the board, and then get it to the state for implementation January 1st of 2020. So, which is a short window, but it's doable in that we have already held all necessary hearings for this. All that really has to happen is an adoption. And I asked specifically to the state, can we do this? And yes is the answer, because essentially we have a 2015 started process that is still open. And unless we withdrew those applications, which we clearly didn't, then we would have to start, so to speak, with a new notice to DLC and a new, evidentiary hearings and all of that. So I can brief you guys enough to get you comfortable with moving forward, but and then again, sit down and spend the necessary time with you guys to go over it. That's not tonight, obviously, but very shortly to do that.
So, yeah,
Within the next couple of weeks.
I believe we would like to get through this by 5 if we can, but,
That'd be
so,
great.
so with that, Darwin, you say 2015, we've done all the notice. We probably should still have a hearing or two for public to be able to comment on that before a decision was made. So if you were to, and the planning commission said, yeah, Board of Commissioners adopt this, what flexibility does that take away from the planning commission to be able to, as things come forward?
So, I don't think it takes any ability away, and let me go back to trying to make it clear that we were not trying to adopt anything that's not already in state law that we were supposed to be following anyways. So, and only thing that we were doing would have been adding uses that over the years have been allowed either by the legislature itself or the voters, however law got put into place in the ORS languages, specifically under 215, 283 sub 2 uses. Sub 1's uses in the ORS are, we have to apply them directly, and then those uses in the sub 2, we have to adopt them in our code before we can even allow people to apply for that use specifically. So there's, I think we're into like, it goes all the way through Z, sub A through Z, plus I think it's into maybe double F right now. So there's many uses allowed in the EFU zones. And our current zoning ordinance only lists probably about 15 or so, right? So there's a whole lot more, wineries, things like that. Not that we're going to see those, but those would be one thing that takes up a lot of language in the model code. And anyways, so I don't think that the Planning Commission loses any authority. Again, this is stuff that already should be in our code. If we had large staff over the years since early '80s, then these updates could have been happening on a ongoing yearly basis, which most large county populated counties do, because they have the planning staff and resources to actually update their code yearly with the new changes at the state level. That was the intent of the Eastern Oregon counties when they presented our grant application to do a model code, to actually fund that opportunity and to have the state give us the exact language that would go into our codes each year. Now that this is 5 years running, I have not yet seen that happen. And you know, template, even applications would be something that would change. We're running off of a pretty early land use application that doesn't even ask the applicant for the criteria, how they meet the criteria in our applications to date. So there are some examples from other counties that before January's implementation, I would be updating our applications as well to make sure that the applicants whose burden of proof it is to meet the criteria is actually addressing those in their application, which to date almost never happens. Only large
Basically, you're saying
projects.
exactly what I said earlier, we will
Yeah.
follow the state.
Yeah, we just follow the state rules, and there really shouldn't be any reason why the planning commission would have a problem with that. I mean,
Do those rules encourage, and this is one of my questions, do those rules have with them a fee schedule, a fee?
no, so that, I'm glad you're bringing that up, and I know you guys want to.
A fee structure?
No, and so a fee schedule, you know, the county typically will look at our fees for established fees every 18 months. Correct me if I'm wrong, Mel, but that seems like our schedule, that we would update fees every 18 months if needed, and those department heads could come before the board and say, hey, we need to update this fee, similar to what the building department's done recently and implementing some.
We have to run 2 hearings at every.
Yeah, there's a couple of hearings for that. We, about 6 years ago, updated our fee schedule. I guess it's been a little over 5 years ago, updated the fee schedule to change solar projects from base application from $250 to $1,000 and up to $2,500 of actual cost, and then 50% of all costs after that. That was a change that I brought before the commissioners then, 2014, knowing that we were getting a lot of solar applications, and you know, knowing it was taking a lot more time than just $250 of the planning commission. Back then we had heard a couple of appeals as well. But that helped, but in some ways that's still nowhere near what we could and what other counties are certainly collecting. I did ask that very question of other planners, and you know, of course I got across the board, but most of the smaller counties were even below what we're at right now. Doesn't mean at all we can't change it, so.
It's not necessarily about what we could charge, it's about how.
Getting what it's costing us to.
Yeah.
Because, yeah, being stretched thin as I am already as the only planning staff, you know, a lot of these applications for major projects take a lot more time than what just a simple non-farm dwelling would, which obviously we'd switch down to $200 if we kept with the current fee schedule, if we got that updated to a type 1 use. But then planning commission isn't reading as much. So I've talked a lot. I want the planning commission to have their time, and I hope you guys can stay longer than 5, because I think we don't start anything until 6. I know, you know, today kind of ends at 5, typically around about.
If you need to take off, that's
Yeah.
fine.
Yeah, if I.
Yeah,
We'll still
I
have
understand
it
you got personal things.
We'll take the time that's necessary. I thought you guys started at 5. so.
Yeah, we don't start till 6.
Okay.
So, do you guys want to just take a stab at any of the things on your mind?
Well, I'd like to start, because you plopped an email up there that we all had time to read as you were monologuing along there. And I think the question was stemmed by one that I wrote. And my question wasn't what the planning commission's role is, although that's what I asked. I know what our role is. My question was, what is the planning commission's role if all we do is ratify the planning director's predetermined outcome? Why do we exist? These projects are either written for approval, or the planning director discourages them from applying in the first place. If we deny one that's been written for approval, the decision can automatically get appealed to the Board of Commissioners, who override our decision without providing answers to why, how, or what we should have done. It's embarrassing when our priorities don't align with the Board of Commissioners. We need feedback on these that get appealed, or at least some follow-up communication, or at least an invite to the meeting where a decision's gonna occur. So my question wasn't, what is our role? My question was more around, if we decide to deny an application and it gets appealed, there's no knowledge, we don't ever increase in knowledge of why it got appealed, why the appeal was changed, our decision was changed, so we don't make the same mistake again. If we're gonna we need to provide reasons, I guess maybe I need some reasons on, some examples of what criteria are that justify a denial of an application. I don't know how to do that. I feel like we try to read the criteria Darwood provides, and if we disagree with his findings, we state that, but it's completely subjective. And it's like that, my question is more around that, not necessarily what our role is. It feels like this last meeting, when we had 3 decisions that we made, all 3 were overturned. Why were they overturned?
Okay, so I'll take Brad's shot at that. Each
So,
county commissioner will have everything. We can't talk specific about any ones in general right now because of the appeal processes are there. As a board of commissioners, as Brad Winters as a commissioner, whenever we want to be able to support the planning commission's decision. So whenever we get an appeal to us, we have to look at the criteria and the facts and findings. So you guys take the criteria, and you guys have to put together the facts and findings why you would not support this or you would support it. It can be either way, it can be appealed to us. So we have to look at what you put in writing of the criteria and why it either meets or doesn't meet it. We're not planning experts ourselves. We rely on our planning director quite a bit also. But whenever it's billed to us, we're quasi-judicial. So it's a whole different way. But we have to look at it. We take our own emotions out. We take our own views out. We may grandstand a little bit every now and then with an opinion. But whenever it comes time to make that decision, we're going to look at what's in writing and what the planning commission brings forward in writing, the reason why it doesn't meet this criteria. So if it's on wildlife, we need to know why this does not fit, why you support that this is in winter range or this is whatever it is. And most all of them come on conditional use process. So we need the tools from you guys to support your decision. And I'll speak for myself, I want to support your guys' decision. But we have to have that. Whenever it gets appealed to us, we have attorneys in front of us, we have all kinds of people in front of us bringing some prepared documents why it doesn't meet the criteria and or why it does. And so on. So that's the tools I need as a board of commissioners. I need the best documentation showing either in favor or against how it meets the criteria and that kind of stuff. So I think you guys, along with the planning director, sharpen that up a little bit so that we're able to support the decision that you guys make. And that's where, I'm talking in general, that's where I see that could be shored up a little bit. But
So maybe make sure I understand, because they're like, and we can't talk specifics. So there's oftentimes a larger discussion, a larger context in which the decision was made that's not always captured in the motion that's given. And the motion that's given seems to me like maybe that's all you're seeing, or are you seeing the full minutes?
well, we do get all the documentation, all the minutes and everything, but when it comes to the facts and findings, you need to write that out specific. The visual impact of this, it doesn't fit by the criteria because of, this takes away from scenic view because there's an ACEC out there, or this is next to a byway, or so on. Not because the neighbor doesn't want to see it. We need the criteria that says this is an impediment to this part and it fits the facts and the findings. Yeah, we do read the minutes and all that, but we need to know, we need that in writing so we can easily look at the reason why it doesn't fit that criteria.
So Commissioner Winters, I think when you say criteria, can you define that? Because I think that one of the things that we, some of the planning commission members are struggling with is opinion versus what is required by law in the ORSs, and that the criteria is based on those. Is that what you're trying to?
That's exactly,
Okay.
whenever it comes to us in this official capacity as an.
You need a
as an appeal,
referral
we have to
to,
be able to, what you refer to as by
Yes.
law, by rules, by ordinance and all that
Correct.
stuff, and that's the criteria I'm talking
Great,
about.
thanks,
Your facts
yes.
and findings towards the law, whether it's local law, state law, or whatever.
correct.
But isn't the law always subject to interpretation? I mean,
Absolutely,
that's
every single decision within one of these CUPs
So
is, I mean,
Sure.
to point at the law as something factual, it's not. Unless we have interpretation to go along with that.
the fact that any land in North Lake County that's not irrigated is considered of no farm value is absolutely ridiculous. And that's something that's supported time and again. That, I mean, that
Quoted.
makes no sense. Why don't you, I'd like to see, I mean, you guys stand behind that on decisions you make and back up, tell that to your constituents up there. Tell it the young guys trying to get started with something, every little chunk of ground that disappears one at a time. I think that there needs to be a lot of things taken into consideration. I'm the longest serving board member here and usually the outcast, and I'm totally fine with that. However, in all the years I've been here, I think that one time, there's been one board of commissioner to ever attend a planning commission meeting, and I think that that is ridiculous, given the decisions you guys have to make farther down the line. Not involved, it's a public meeting, not to be involved, just to be there to see what's going on, to hear your constituents, whether you agree with them or not, to have no involvement, I feel was wrong.
So I have attended 2 meetings, one as a commissioner representing county-owned land, one as a private person representing acreage, small acreage I own. I've always kept my separation because of the appeal process, and that's been my decision, is it gets appealed to us, and the criteria and stuff's brought forward to us, and I'm not saying that's the right decision, that's been my decision. We appoint planning commissioners to make decisions and bring them before us. And so with the appeal process, I personally have opted to not go to the planning commission meetings. To answer your question, that's where Brad's at.
Well, my understanding is that we can attend those meetings.
So you
That's why
can?
I can, but we'd have to disclose our attendance of it, and it does make it more complicated later on if things are appealed.
I think
And,
it's just
but
the
you have to
opposite.
disclose the fact that, yes, we were there, and we still have a responsibility to make an unbiased decision at the end.
Totally
It does
agree.
make it more complicated, it does make it a little bit, it muddies the waters a little bit if there is an appeal. If there's not, there's no harm, no foul. From my perspective, that's where I was, and that's when I attended at least one of those meetings as just a member of the public and as myself, not as a commissioner. But I understand that in our role, it does make it hard for us when we come in and we see all the board, you guys as board of commissioners, looking at us constantly and, eyeballing the fact, oh, there's a county commissioner in the room. And we don't know if that impacts your guys' decision. We don't like to impact you guys' ability to run the show. And so sometimes there's that added stress of the fact that when we're in the room, we know that our presence is known. And we're not sure how that impacts you guys' decision.
I can't argue with your interpretation of it, I'm just telling you my
Oh,
opinion.
yeah, no,
That
absolutely.
I think that the board's wrong, the board of commissioners is wrong to not have more involvement, especially when you're looking at appeals and there's no communication. No, I mean, we didn't, personally speaking, on any appeal that's happened, no reach to the planning commission, who can also attend as public to hear the process, to see what goes on. From my standpoint, from the time I've been on this board, I feel like a rubber stamp, and I'm done with that. The end of my term in December, I'll no longer have my name attached to decisions the county's overturning or the board's making, either board, planning commission or BOC. I just don't agree with the direction the county moves and the way it does it.
Should we?
Can I say something? Yeah. So, on your comment, I'm sorry, I've never met
Wes Davies.
I've never met you. Your comment of, as far as us not coming back to you with the reasons why we made that decision. I don't think we can legally yet. And so we have to abide by the law. And so I'm probably speaking for the whole board, but when this appeal came up to speak, or to have this appeal process go through, I didn't sleep for 2 nights because I'm with Justin. I don't particularly like the solar things, but I had to take out my personal feelings and abide by the ORSs and what is stated. And so I would love to make comments, and I think we should, after this appeal process is over. I think we should get together and say, this is why I made this decision on this particular deal. But we can't. And so, by law, we had to follow the ORSs to our best ability, and none of us are lawyers. We did have our lawyer present by phone. One of the things that I want to go to speak to both boards about is we can't take this personally. You know, whether your decision, I don't like your decision, or you don't like mine, vice versa on our board, if we don't agree on it, if I take it personally, then nothing's going to work. And so we got to be really careful about, especially in a small community, to talk things through like we're doing right now. I wish we had more room to talk about things specifically, but right now we can't. And, you know, they might might overturn our decision, and then we're gonna have to go back too, and which we probably should anyways, whether they agree with us or don't agree with us. And so it was a really hard decision, and we were in that meeting for 10 or 11 hours, you know, and
I didn't leave the courthouse till after midnight.
and so I just want to say that because we had those things in our mind too. I had to work at it not to have my personal feelings involved, because I would have probably not made that same decision if I would have. And so, go ahead.
I want to zoom this discussion out a bit and talk about solar in general, because your personal feelings can't affect any one decision, but they ought to guide our direction as a county. And at some point, we don't want to wake up tomorrow and realize we got 400,000 acres of solar panels in this valley. So where's the line?
And I totally agree with you. And like irrigated farm ground, I'm totally against, but the law doesn't separate whether it's irrigated or not irrigated.
It talks about it in the CUP finding on high-value farmland. Talks right in there about the ag value of it. It's the bullet that we've sent to you guys with objections in the past that have been overturned. It's right there.
That's a specific criteria we've referenced on
To
some of
Brad's
these.
point, referencing a specific criteria. We've done that time and again.
So, like I said, we will talk about the last
No, I'm
appeal
not
process.
talking about it.
Prior to that, has the Board of Commissioners overturned any of your decisions?
Didn't they overturn the only other one that was appealed?
I can't remember. I can't remember.
The other
It got
one,
remanded.
the
It got
Board of
remanded.
Commissioners, it was up on Arrow Gap, the previous Board of Commissioners, myself and others, and we upheld your guys' decision, if I remember right, and a little bit overturned that decision based around what ODF.
Correct, yeah.
So the only one that's been overturned could be just the recent one.
Correct.
So-
Wasn't that Sims one overturned?
Yeah, that's the one.
Oh, yeah,
Yeah,
that one was overturned.
That was a remanded one.
The one-
That was a different situation.
Yeah, I think that's
specific.
Yeah. And so, Wes, you want to talk about solar, we can go there. Remember, under the CUP, it's for everything, whenever it comes to us. Solar is one part that people do CUP for, they do for non-farm dwelling. well, and several different things can be appealed to the Board of Commissioners. But you want to talk specific about solar.
Yeah, maybe my question and discussion is more appropriately approached from those seats than this one, as a member of the county as opposed to a planning commissioner. But the comment was made during our meeting that whether you approve one 3,000 acre solar farm or 10 300 acre solar farms, the result's the same. And at some point, does the county want to create policy right into our ordinance, something that guides these solar projects, identifies priority areas or areas of allowed development, identify areas we don't want to see development, like maybe just irrigated land, you can, something like that to help us, because frankly, we can pick any criteria and subjectively apply it or interpret it our own way and deny any based on our own interpretation of the law. But it does no good if it's just going to get overturned later. So I think we ought to have a discussion a little bit about solar, where we want the projects to happen. Maybe the answer is private property rights, and
So,
we consider them all.
Wes, I'm going to get on my bandstand a little bit, take off my commissioner's hat. I'm sort of.
You can't take that hat.
Well,
I'm sorry.
I'm a private property rights advocate, and I hate government telling us what we can do with it or what our neighbor says we can do with it, what planning commissioner can tell us what we can do with it. Pay the taxes, I buy it, and my neighbors and the planning commission and the board of commissioners say you can't do this on there. That really bothers me. For a lot of years now, all the way back to whenever the previous board had unsigned death threats over solar, I've supported a process. And as long as there's a process, there's going to be a certain amount of manipulation to that process. And whenever you have investor developers, they're going to find every loophole in that. So I really try to pride myself to take those personal views about my private property rights advocacy and say, if it follows a process and it's allowable by the process, we have to do that. And that's the dilemma that we are in, is that process allows quite a bit of different interpretation. And you talk, Wes, about the interpretation of the law and everything. I believe that yes, we all interpret the law a little bit different. We rely on our legal counsel a lot on that. We rely on our planning director a lot on that. But the more it's shored up whenever it gets to us, this is the reason why we see the law states to this. Write it out there. That would help us. So, Justin, to talk to you, thank you for your time on the planning commission. Whenever things get tight, whenever things get tough like this, and you don't really agree with everything, sometimes that's whenever you get a little bit more embedded and try to help change the process. So if you want to step down, I understand.
No,
but you know, government is a process and everything. So we're looking at the ordinance, the model code and everything. So I work with you on other things. I know that you're very invested in many different things. But just an encouragement, if you wanted to stay on, you'd be welcome to.
Yeah, I appreciate that, Brad. I'm done. I think that what Wes is getting at and what you talked around a little bit there is the fact that this county needs to address solar development. What did we find out last time? There's 17 approved solar development projects within this county.
Well, there's 17 and 15 of them are dead or something like
Well,
that.
but they're still CUP, they're active
There's still active
CUPs.
CUPs. for
So
projects
I
that
agree
are
with you on a process, and the process right now is horrible in this county, and it's a shotgun approach of any landowner willing to sign a contract and create a new LLC. There needs to be a guided approach and a process. To your point, the problem is, we need to get there. The time I've been on this board, we've asked 3 different times to sit and have this discussion. This is the first time it's ever happened, it's gone on for like 3 years, asking, because as the Board of Planning Commission, we see it coming down the line constantly.
We're really actually late now.
We're behind it, and that's why we've
We're
asked.
late now.
You're asking people up here to make decisions that they have no right to be making. We don't have any education about the actual benefits or drawbacks of solar. I'm personally not even against it. I have a bunch on my own place for different reasons. But I think the way we're going about it is completely wrong. We're picking and choosing winners by capacity on the lines. I mean, do you realize any of those kind of things we're making decisions on? Looking long-term? It's been eye-opening to me, which is why we've sat and asked, or at least myself, have asked to have these meetings to build a process that dictates how we get there. Because just right now, approving any random CUP that comes in, because it meets the criteria, which is junk in my personal opinion, that's how we get to where we are right now.
Well, in our defense, we've only been here about 8 months.
Right.
So, you know, in the last 3 years, if you've been asking to do that, we've been really trying to make that happen.
True,
That's why this is
I'm not
a
making it
good
personal, I'm just talking about one
Yeah.
board to the other. You're trying to get guidance, so we don't end up, as Wes stated, behind the ball.
So one of the things is that, say we made an ordinance where you can't put solar on irrigated farmland. Would that even hold up? Would that hold up? I mean, since state law is different.
Our definition of irrigation farmland, irrigated farmland has to be understood and be comprehensive. Because if, say you have a piece of property in the south end of the county, we'll just say, that has no water rights on it, or say it goes up to the north end and it has no water rights on it, and there's a moratorium on it. And I just got a notice today that our water master is going to be moving the district, and all the water master is going to be handing over the entire north end of the county to District 11 for management, and that's out of Deschutes County. And that's what they want to do, so I'm trying to understand that right now too, because
And that
that means
moratorium could go away that fast.
correct, and so I'm trying to understand how that's going to affect that, because the entire north end of our county, all those pivots right there, all those farms are going to be managed by a water master out of Deschutes County now, and not someone out of this county. And so,
How did that happen?
if you want to see it, it's right here.
All water is governed by the state.
But it's
I
a
think you got an email,
state
the state oversees it all anyway, but the point is that the water master is probably going to be out of Deschutes now.
They redistrict the lines and
They're-
it's all governed by the state.
Yeah, they're
State.
redistricting the lines, just
Moratorium
because.
might be over, or they might.
No,
or
no,
they might-
no.
They might,
We don't know what that's going to do, but my point is if you have a piece of property that doesn't have those water rights on it, and there's a moratorium, and you can't get water rights on it, and we were to say, yes, this solar is to be developable, but you can do this on this piece of ground, but that ground's not zoned any differently than one of those pivots or something up there. And the state doesn't view it any differently. I agree with you.
Where Justin's coming from in our definition of high-value farmland
I
is
agree.
based on a Willamette Valley standard right now. It seems to be.
It is, it's
Based
on
on
soil
soil
classification, it's not
classification.
even achievable in Lake County. And furthermore, just because there's a moratorium up north does not mean you cannot put water rights onto a piece of ground.
Correct.
You can transfer,
You can
and it's
transfer
done
those
every
water
year
rights.
repeatedly.
So Mark's question is, irrigated farm ground, and is it even legal? Now, I can't answer the legal side of it, but how can government financially harm a private landowner by saying you can't do this and you can only do it in a certain area?
So then what process do you
You know,
support,
I
right?
don't
mean,
know.
that's what I wanna know. You're in favor of process, so what's an example?
He's supporting private
Process.
property rights.
Everybody has private property rights on
I-
both sides.
But
So
that
you want-
Exactly.
doesn't
Yes.
mean you can put a carnival in up there.
Exactly, that there's a process to get through it, which is the
But solar
CUP
is an
process.
allowable use.
Agreed, under interpretations within the CUP.
But we're told repeatedly in all of our information that we can't be biased and you can't just vote against something because you don't like it.
I didn't say that, I'm talking about within the findings, I don't disagree with that, and you're talking about information provided, no offense, but from one person, not from anywhere else.
Okay, well, I'm from the north end, I see sagebrush. We can't talk about recent things,
Mhm.
but I kind of feel like I can't really make a comment because this is on appeal.
Yeah,
So,
Well, let's talk
I-
about that.
I-
We'll talk about the
so-
north end. We can talk about
But
anything.
you're talking about the north end. and
We're a
how
big-
I was talking
sagebrush.
about water rights.
But you were
on the
talking
north
about sagebrush.
end. On pasture, absolutely, I
Yeah.
totally agree, because I've
And-
made half my living off of leasing outside small pieces that are sagebrush, that have grass, that spring pasture and somewhere to cap. And then I come sit here and I'm expected to sign a piece of paper that says because there's no water, it's low value. So how about the outside country your folks run on, or have, or lease out, is that low value? No good value ag land?
it's not zero,
Right.
but you gotta you can't run a lot of cows on a whole bunch of acres.
Agreed.
And something like solar is going to bring in revenue to the county.
And I don't have a
And you
problem with
have-
solar if
but
we
you
have a
have
plan.
An alternative to bringing in revenue, I think everybody would be
I
interested.
don't disagree with you on that. I'm talking, it follows along with what Brad stated. This county needs to have a plan, not a CUP. I mean, what's the map look like right now of the approved CUPs for
We're
solar?
looking at it right there.
So, Justin, you guys are talking
Those are
about
the
something
approved
that's a
CUPs.
real challenge. I have my dream, my piece of property out there, it has very little surplus water right. Across the fence has really good alfalfa. I'm trying to do a little dry land farming and trying to make it with my small herd of cows. That's, to me, of high value. But to you guys sitting as a planning commission, when you're looking at that compared to an irrigated ground, what's the value of that? To me, it's pretty valuable, but it's probably not going to really raise the amount of cows it needs to make it valuable.
I don't
And I
disagree.
think that's just in what you, I know your operation, I mean, you move from here to there on some of those small places and take care of the grasses as they're coming on, and that's a value. And that's where the interpretation of what's high value and what's valuable is really tough to be sitting in any of our shoes, that part right there. I get back to where is government and private property rights telling people is yours is high value or not. If you have water, yours is worth more than this person. But even if you have water and you're producing this amount, and if you cover it with solar, you're gonna make twice as much than you are off your alfalfa. How can we harm somebody from making money? Long-range plan, let's say, solar lasts for 30 years, let's go 40 years. It's moved off. That soil classification, that value of that soil is still there. We're here for a short time in the real life. It can go back to being farmed on the longevity.
Well, your water rights are gone in that scenario,
On some,
on all of it. On anything covered with solar, if you for 40 years, your water rights are gone. State law, done. And I know it's probably hard to believe in here, but I don't have a problem with solar if we have a plan. But this county is just passing anybody that wants to come in under any LLC and saying, here you go. But there needs to be some long-term vision.
I need
Go
to
ahead.
interrupt
Go
for
ahead.
just a moment, Melanie.
okay, Melanie's after you. Go ahead.
Oh, well,
No.
so as a public person, I was wondering if you guys could put a cap for the county on how much solar is produced. So once you approve 50 CUPs, but if the first 13 CUPs to come into fruition for their project meet that cap, then the other CUPs are out of existence. They'll have to reapply and get back in line. Would that be something you guys could entertain? Say the county will produce so many thousand megawatts and then readjust that if needed? Would that be a solution? Then you could still have some private property rights and then still support, I don't know.
Maybe condense it down to 8 or interpret it by acres and not just megawatts, because as technology develops, megawatts can increase.
And to some degree, that's already happened because of available line capacity.
Right.
That's what
It's
we've
gonna be
already.
limited by.
I agree with you, I get where you're coming from, and that the counter argument to that is then you pick winners and losers by who applies first and who applies last. The flip side of that is we're already doing that by the capacity that's available and who can develop the fastest, and these are some of the concerns I have. I know, Allison, you might not believe it, I don't have a problem with it,
Well-
but I think we need to have a long-term plan and vision for how it's dealt with.
Well, part of it too, though, is in some of these areas that you're talking about, we're approving so many more non-farm dwellings in that area. And that's, I feel, starting to impact ag purposes.
I don't disagree with that either. I feel like in that specific area, being North Lake, I felt, and that was a discussion I walked in late on, but that our back's always been against the wall with the Penn Phillips deal and some of those other
Well, and
smaller
I'm even
lots that are
talking about
made.
some others that, were part of the sagebrush ground that you're talking about, trying to lease.
Mhm.
We've got 40 acres here and 40 acres here.
Generally, those are the guys to lease from, because they put a house on and don't do anything else with it, however, irregardless. I see what you're saying.
It's not an interest. And we
Right.
don't have, I mean, Christmas Valley is not a grazed cattle
Mhm.
area.
I
Fort
believe
Rock is,
West has,
Silver
Yeah,
Lake is.
see,
Well, I was wanting to kind of drive this discussion forward a little bit. I mean, the attitude that I'm hearing and the answer to my question that I'm getting is that the private property rights prevail and we don't care to put any restrictions on those. That's what I'm hearing. And
well, that was sort of Brad's words, I'm only one out here. That, and I tried to make a separation from my personal views in commissioner, but that's hard to make that
Well,
separation.
my personal view is the same, Brad. I agree with you. I don't want anybody telling me what I can and can't do. At the same time, I would hate, as a ranch owner, waking up to tomorrow, both of my neighbors with 1,000-acre approved solar projects, because it affects my property value and its resale value, and that bothers me. And so we need to come up with, I feel like we need to come up with some direction. That I like the idea of maybe an acreage cap, maybe that's an option. It doesn't mean we have to stop there, but it means when we get close to that, we have this discussion again.
I have to tell you, that exact thing came up, and the comment that came back to us is, yeah, your property value went up because now it's worth something to put solar on. So be careful when you say that,
Sure,
maybe you're better.
sure, that's
And that wasn't my comment, that was over some hearings over the several
No,
years
I-
I've been here. But,
No.
yeah, I get the solar thing. We are, I believe, within, until bigger lines are built, if they ever are, right at the capacity of what solar can be put in. And I'll say the Lakeview area, North Lake, if things are approved, I think they're gonna be close to their capacity also. That's what I've been told, I haven't checked into it.
So maybe it's an irrelevant discussion then. The other thing we do need, probably ought to talk about is we've got 13 of these or whatever that are approved, that are dead, and really progress has stopped. Should the approval be revoked, or not the approval, but the permit be revoked?
Expired.
They have
Well-
a date certain of expiration.
Yes and no, like, because our criteria usually says that if there's substantial investment been made, then it's still valid.
It's perpetual.
I mean, because these companies aren't gonna put, boots on the ground usually within that first year or even 2 years. They have to do their studies and, the cultural studies, wildlife studies, all these kind of different things. None of them are gonna do anything without a purchase power agreement. They can't get that until way after the fact, of these other things that have to happen well before that, so. We could, and we've had that discussion too, of maybe the solar companies can say, hey, which of these lands are you done with, but I think in some ways they're probably, trying to hold on to those approvals to then possibly sell them to other unknowing developers or people who want to go out in a different direction and have different ideas of how to get that power out to the grid when they don't have the lease agreements in place and things like that to go up big county roads or across private land and things like that.
So from my standpoint, sorry, go ahead.
Well, I've heard John Muir say, I'm seeing there's 30,000 acres of solar are on the horizon and stuff like that. I mean, this county to date, what's approved is almost 2,500 acres of solar. That's what is on the books, and that's roughly
That's been approved, that's total
16
that's been
projects.
approved?
Yeah, I'm got it on the
It feels like
website
it
now.
should be bigger than that.
It feels like it's bigger, but it's not. When we talk about what's actually developed, like on the grid right now, we're talking 286 acres. I mean, you're talking less than one pivot, when you think of a 320 acre, so there's not a whole lot, but the potential is large, and I have of those lots that are affected, there's.
That can't be right, Darwin. There's more than 300 acres right here.
Not yet, there will be, I said on the grid. By the end of the year, there will be another, 320 roughly from what's being developed out at the airport. But Brad mentioned it, the solar developers have mentioned it, that the grid is at capacity, that the capacity's already been bought up by Newsom, bought most of it. So Obsidian's projects are, largely dead, is what Jacob Stevens has said to us. If he builds his projects first, that capacity will be soaked up, and more than half of the projects in the North Lake area will never happen because of that, unless more capacity is developed, more lines, and that's almost impossible.
Well, but so is that what we're driving by continuing to issue CUPs? We're driving the defendable position from the solar companies to argue for more capacity? Because they have it out here, it's just waiting, all we need is to build that extra capacity. Is
That will
another
always be the argument,
unintended
but I
consequence?
kind of referred to like B2H, which the board meant anyway, that's been
I know.
a plus
That's what I-
10-year
Exactly.
process, I mean, everybody's gonna.
But it
be
doesn't
in front
matter
of
if it's
something
10
like
years or
that.
20 years or 40 years. I mean, we gotta look long-term.
Correct.
I mean, we're raising little kids right now that are gonna have to be stuck with decisions that I don't know I want my name on. What opened my eyes to our solar issues and why we needed plans originally with me, and I brought it up, it was an obsidian application, was I asked for there to be an amendment made to their CUP that at the, with 1 year of inactivity after a solar project was put in, that they clean it up. I wanted something in there that if it became an obsolete technology, which someday I'm sure everything is, that the site be cleaned up and put back to what it was, which was to your point, Brad, about the soil still there. The answer was no. They considered that bonding, and no one back east of the investment portfolios that actually own these projects do not want anything bonded, and they don't want any tie back to something they would have to do. The answer was the county already has a nuisance ordinance that can enforce the cleanup.
So along that lines, and Darwin, correct me if I'm wrong, is there has to be financial assurance, not bonding.
Not by the county.
It's not bonding, they call it bonding.
Yeah,
I'm not asking for a bond. All I asked for was in writing a condition within that CUP.
And we put it in there, you're talking about the one at Fort Rock when.
I started this with a
KR
bunch
Solar.
of them.
Yeah,
Now, it was
but-
sitting in here, not at Fort Rock.
Okay, so at Fort Rock though, when we had that, I mean,
That was the
it
private,
did get into.
and that was a landowner that was doing it, and the landowner was one of the first we've ever seen that were actually driving it themselves, not somebody else coming in. And the landowner said, absolutely, you're right. When you have an investment company driving it, no, because that is considered in their eyes bonding. And all these guys sell these to third-party investors. They're all owned by hedge funds.
So I believe this current board here has asked for that financial assurance. I may be wrong, maybe I didn't follow up on that, but we've had that discussion. Or was that prior to you coming on, Mark?
Yes.
But I
We
think,
talked about it,
we-
but I
I
don't
think-
think in a
It's
official capacity.
pre-conversations, but I recall the same.
yeah, and because that has been a concern that's been
We
brought
talked.
forward.
So it seems like there's a lot of little pieces right here that need to go into a driving force for a process. We talk about little pieces of it, but we're not getting.
But I'm thinking it's written into one of them, but I'm not sure, but we.
Kevin's got a question.
Go ahead, Kevin.
So you might have just answered this, but there is no exit strategy.
No, none. We come in, we develop it what they're doing is developing it for the 30 years, they have a tax incentive to do it, and they leave. It is back east investment money that buys these. Outfits like Obsidian develop them and manage them for a fee, and some hedge fund portfolio buys the tax break. We were told that at the last one of our commission meetings. We're in a hurry because we're up against the deadline. Our tax break gets devalued if you don't get this pushed through. It's exactly what's going on.
So, Kevin, we've had that discussion as a board of commissioners over the years, and whenever Dollar General, Kitty Litter, whatever is developed, we don't make them have to have a plan for exit whenever they go out of business. And so this is a little bit more unique. I agree with that, but as we try to attract industries to come here, Red Rock does not have that on them out there. We try to attract industries.
But Red Rock's not dealing with hazardous material that could, the potential for a super fun, these solar projects do.
So as you're trying to get development and growth within your communities, we've had that discussion. Where do we do that? Do every grocery store that's built, if we can get one built, say that you have to be ready to clean that up when you go out of business? Do we tell all of them that? So that's been some of the general discussion that we've had as we've went around this multiple times. Whenever a rancher builds 6 hay sheds, we don't say you have to clean those up whenever they're done. Even though some of them out there, they're taking care of themselves.
There is a difference.
I guess where I'm going with all this and just those comparisons is what is the reach of government? are we overreaching at times onto the private sector or whatever? What is our role? And our role is to try to protect the citizens best we can without too much overreach in my view. And so, yeah, this solar's new. It's a new development in our world. Yeah, there wasn't money set aside when dams were put in for those to be tore out. If they, today we're seeing that happen.
We gotta learn from that mistake, though.
Yeah,
That's the-
well, that's probably a good point, Wes.
So,
I still think it's the most renewable energy we have out there for myself, so the cleanest.
in the interest of time, I mean, it's 5:20, we've still got some time, but what I'm wondering, and I don't know really honestly what the rules are around this, is this whole issue worth developing a working committee or someone to, a group that, of us and or others from the community that want to work on developing a process that he's, you know, that Justin is talking
Actually, Brad
about?
recommended it first.
I think we
Right.
should just keep it between the two
Keep our
boards and
conversations
and-
going?
keep the conversation going. I'll make some notes. I'm gonna contact Jim Bailey to make sure that if we create these ordinances, are they legal, are they binding? You know, what spooks me a little bit on the solar thing is that the state is mandating a certain amount of solar all the time. You sure in the shit don't see it happening in the Willamette Valley. And so they're just kind of almost pushing this down our throats.
Which is more of the reason to have some parameters to
But
work with.
but what I'm afraid of, Justin, is, so we put these ordinances in, and the state's gonna go, mm-mm. But that doesn't mean we shouldn't
Yeah,
try.
I think at that point, you're satisfying a bunch of your
Well,
constituents.
and I appreciate where you're going with that, but when you talk CUPs, we're talking specifically about solar right now. We have non-farm dwellings, we have other things that go for a CUP. And once we start pulling out one, and we start building ordinance for one, what does that do for others? I'll disclose, my 14 acres going through the CUP process is my heaven, that's my pride and joy. And I like having that opportunity to go through a process to be able to have my 14 acres. I now have other land that would fall underneath, I believe unless I go to the 360, that's where I can put a place, but there's a lot of dreams out there through the CUP process that aren't in alignment with the farming side of the world or the cattle side of the world until that farmer rancher needs to liquidate that 10 acres to help pay for this or that, or their family member wants to separate and have that 10 acres under conditional use. So as we talk solar and we talk CUP and we talk ordinances, we have to cross back over and look at the whole CUP process and what it will either trigger or not trigger it. I get right now we're in the midst of solar development in Lake County, but there's a lot of other things with CUP process that happens through the planning commission.
And like Wes was saying, I want to be able to build a house where I damn well please, you know what I mean? And so.
And your neighbor may not want to see it there.
Right. Then you're cutting into that, and it's like, I don't even.
So if we have, I mean, I'm having difficulty with the issue around the cleanup for the solar, because either I dreamed it, which I don't think I did, or it actually happened that we have had some assurances and some legal documents that state that, and I'm thinking specifically of Obsidian, that at the end of the road, there is a cleanup plan. And so, I mean, is something, can that
I think we did
be?
it once.
Well-
It wasn't with Obsidian, it was only with KR Solar.
Yeah,
It was Randy
we did it
Coons.
one time, but we have not done a good job of making sure that happens every time.
And you're saying something there, if the CUP is approved,
Mhm.
And this was getting back from Kevin's here also on roads and everything. If the CUP is approved and doesn't get appealed to the Board of Commissioners, the stipulations that you guys put on those is where it really sticks. So the financial assurance or impact to roads or impact to the neighbors and different things under the CUP process, you guys get to add some of those, the opportunity to add some of those things on to be able to, we will approve the CUP, but we're gonna have this stipulation on it. Say it's a solar place and you're gonna have a berm 10 feet high, that's a requirement for the approval of the CUP. Never gets appealed to us. You guys have done your job and that's there. The financial assurance, I will say for me individually, I would like to make sure that you guys trigger that on the CUP process, is that there has to be financial assurance. There became an issue with having them bonded because it's out so far. They couldn't get bonding companies to bond it, so we had fallen back through the Planning Commission and others. I'm trying to remember, and Ginger's got that same look I do. It came down to financial assurances where we was able to finally put the hammer into the approval on the CUP process.
And maybe I misspoke, Brad, but what I was saying is that when I asked them specifically for a cleanup agreement, nothing financial, just a cleanup agreement, they considered that bonding. And then when that was considered a bond on their CUP, it made it less marketable to their third-party investors. I wasn't asking for a bond per se, just an item within that CUP.
Well, and you're saying a lot there, Justin, because these are investor developers that come in, they're selling the projects. So we're dealing with investor developers, and they're going to do the best they can to make the most money they can. So it's more sellable by not having to have that financial assurance or cleanup in there. But as a planning commission and approving of the CUP, you're able to put that language in there. This will be approved upon you proving that you will have financial assurance or that there will be a trigger for it to be cleaned up.
I get that, and I agree with you. I think that's what I was talking about. I'd also like to see the county have an ordinance of that in some way for us to reference it, to stand behind it, specific to solar. To Wes's point, correct. I mean, okay, we'll clean it up. Well, then by the time we do that, what company actually owns it when it's said and done?
Yeah.
Well,
And
it doesn't
whether or not they even
Well,
declare bankruptcy, you know,
We
it can't.
can get into the Alkali Lake drama right now and spend another 6 hours because.
Well, no.
So,
Okay, so.
Once again, learn from lessons.
Darwin, under our land use ordinance in our model codes or any of that, are we able to put anything in there that would give the comfort for the planning commission to be able to address under CUPs?
I'm looking for it now on model code.
And you know,
It's
those
on
are some
page
legal
18.
questions that we have to follow up on.
It's gonna be probably a couple other places, but.
The
So,
statement is,
Kevin, go ahead, Kevin.
I guess I have two hats on here tonight. One is the road superintendent and one is Kevin Hawk, taxpayer to Lake County. And this comment is the taxpayer, from the taxpayer, but I guess using internal knowledge, there are specifics to financial assurance. This landfill has to have financial assurance. So somebody made a comment, and I'm not sure who, about a broad statement on financial assurance and ensuring that these sites get cleaned up in the event that they go under, compared to an alfalfa farmer tearing down their barn. They don't need to go together. Solar can be specific. You can tell these people whatever you have to tell them. If you want them to do business here, then they have to follow the rules of Lake County. But allowing them to be loose rein and disappear, I don't know that that's appropriate either.
No, it's not. Yeah, it's not. So. Let's
Try approving one.
We need to check.
Try denying one.
So if you remember my comment, it wasn't just Hagar.
No, I was just saying in general.
Bedrock to other developments out there. My point is we don't make financial assurance or bonding as development comes in. I agree with you. If we want to be specific towards solar, we need to find the avenue and the right way to do that. I believe that we had already done that through the financial assurance side, Kevin. So I was generalizing and use the hay barn as an example.
No, I understand, it's just hard enough to
Why
look
you
at this,
trade
it's
on.
hard enough to look at these solar panels, let alone think that in 10 years you're gonna have to look at them because they're not even producing anything, because somebody walked away from them, that's unacceptable. And no nuisance ordinance in this county, or it's gonna
And-
cost too much to get rid of them, because you can't get rid of them,
Yeah,
you can't bury them.
Nowhere to go.
yeah.
So it is impossible to get rid of those things.
Right here.
So there's gonna be a spot coming open on the planning
No.
commission, you ought to get on it.
No.
Right here, Justin.
I can't.
Nothing prevents us.
That's a model code that we recommended to the board of commissioners to approve.
It's been a
Which
couple
I-
of years out.
Yeah, which I will be retouching on here shortly. Without the blessing of the state, of course.
So for my time on the board, and what I wanna leave with is hoping that some of this goes somewhere. We've had just like this, we've had this same discussion a couple years over. I mean, it's like reinventing the wheel, sitting here again. And we gotta look out for the kids, for this community. I mean, to develop responsibly is great, and to have a long-term vision. I feel like the process the county is using now completely lacks any of that for the reasons that I've tried to bring up and discuss with you guys.
So, I have a question. Now, in regards to the fact that you originally put something, a requirement during the CUP process, that if this goes, if you guys aren't using this after X amount of time, it's gonna go away, and we want you to have to clean this up or whatever else. And they said no. What happened then? I mean,
We'd have to go
you are
back.
the planning.
We'd have to go back to the minutes and the discussion that entailed from that on
Okay.
what we legally can and can't do, because I can't remember today.
Because that right there says that nothing will prevent you from doing
It's not
that, so.
tough to do.
It's not, that's a draft, a 2-year-old draft that was submitted to the VOC.
So what,
So
It's
that
under
does
state-
draft, that's
That is
not
you.
law.
No.
so under the one that, the language got changed, this is, letter J is what's in state law, which needs to be updated. And I'm trying to blow this up and I'm not getting there as quick as I want to. This is the same as the model code language, exact same, because it's what we were trying to pull over, right? But this is what's been in our conditions for a long time, which is what we're talking about has in at least one case been changed. What I was pulling up, which Brad was referencing, was a 2013 appeal that Obsidian had filed when the planning commission prior, and I don't even think Justin might have been involved in that one.
Might have been.
No, you were, well, no, because it was before you got appointed in October of 13, but, so nobody on this group, but previous planning commission added a bonding requirement, and then it was appealed by Obsidian, and the discussion that Brad was sharing was exactly why that decision got reversed, and the bonding requirement as a condition of approval got removed. This is model code language, and we can require it, and I think with the price of solar coming down, I'm not, speaking for the developer, but they may be more in favor of it, and if, they get, assurances that they're gonna be able to develop in a specific area where they request. And, over the years, I've been involved with solar, for 9-10 years now, prior to coming to Lake County, and, most of these solar guys have been around the game for that longer, and most of them have already picked the sites they want to be in, and they're still working on contracts with landowners to get to that point. And so, if they were more, forthcoming with that information on where they're going to, or where they're even looking to develop, then I think it'd be easy for us to say, with obviously no transmission outside of those areas, that they could reasonably connect to without, not making a project pencil, then we already do have a pretty good idea of where this is gonna go. If you look back at the map that's of the approved sites, I mean, they're in pretty much a few corridors. They're not dotted, pretty randomly out there, but they are dotted along transmission lines. Some, straddling transmission line, where it was.
Do we have a way of knowing what the cleanup cost would potentially be? Can we find that out somehow? Where I'm going with it is,
Yeah.
my next question is about a graduated fee schedule.
Right,
Maybe the fee covers the cleanup cost. I'm just saying, maybe the fee, and not necessarily the county can allocate it that way by any means, but at least the county will have had that income to then clean it up later.
It's a really good idea.
So,
We
They'll
don't
call
want
that a
anybody
bond.
to say, I paid
They're
the
gonna
fee,
call
and
that a bond.
I don't
That
have,
is a bond.
I don't have to clean it up.
so,
I believe that it's sellable from the developer to the purchaser for financial assurance. And for that, I believe that's where we've worked and probably the best avenue compared to the bonding. If you go all the way back to whenever Jim Walls and I were co-conveners for the backscatter site in North Lake, we produced a white paper for the landowners. Well, these investor developers come in and they go to these landowners and they lock up this property with this promise they're going to develop it. The best thing the landowners can do is get an attorney, talk to their neighbors, and don't sign any contracts until you talk to each other. So these investor developers, the wind came right in here in the Lakeview area, and they got all this land locked up without every landowner, and they thought they were the only ones. Happened with windmills further up in Oregon, is we developed this white paper just for the landowners to be aware that these investor developers come in and to get you an attorney, talk to your neighbors, and don't sign any agreements. What does that have to do with the planning commission and everything is these investor developers, they do that and then they go through the land use process. And they have big ideas that they're gonna make all this money off of this. When in truth, a lot of times those investor developers have locked up that property for pennies compared to what the landowners could have got out of it. But anyways, that white paper would be interesting. I can't remember what was all in there, but it's a tool. But I do get back to I believe financial assurance is the best way. The graduated fee schedule that would be held for cleanup, 30 years from now, whenever Justin's kid's a commissioner, and this developer says, well, they have this fee schedule, I don't have to worry about cleaning up, the county will do it for me, would be the fear, I guess.
They pay $200,000 now, and in 40 years, it's $2.5 million, and the county's going,
Go ahead.
Would it be possible to ask Jim Bailey to research the concept of having the financial agreement about that?
That is exactly what your guys' planning director is. You bring that forward to him to have,
Yeah.
get it as specific as you can.
That's what I would.
And
Right.
have Darwin
I
take
would
that
like
forward.
to-
Darwin has right to work with our
Yeah,
legal counsel at any
I'd like
time.
to suggest that, and then Melanie, did you have something?
Well, I was just thinking might be wise to follow the landfill closure thing that we have with the DEQ. We pay thousands of dollars every year to the DEQ for the closure and cleanup of the landfill. So if we could start from something like that, you might not have to start from square one, and then these companies can put in however much money you guys might think that they need to pay, and maybe we'll invest that too, and then it'll keep incurring interest. And so if it does skyrocket in the future to clean up, we'll have some of that money, and then we won't be left up a creek without a paddle, possibly, is what I was thinking.
Okay, good idea.
That's interesting, but I don't believe that we should have to have that financial assurance for the landfill, and they mandate us to do that.
Yeah.
And there's $600,000 sitting there that could go towards operations instead of the projected closure. So
But if
I'm
your
a
neighbor
little,
has,
I'm a little skeptical about taking people's dollars and then there's no expert to say, well, this is what the real cleanup's going to be 40 years from now. I'm a little skeptical about
Sure.
being the governing body sitting here doing that.
well, I think we're still better off than we are right now.
yeah.
Even if it's only 10% of it. I mean, the difference with the land, I mean, if your neighbor had that landfill privately and you lived next door to it, would you want some assurances that it would be cleaned up if it were abandoned?
Myself, I think financial assurance and the burden to manage that money and have it in the private sector better than the government taking it over and having it in a fund that we're trying to manage And then whenever they go to fund, they say, well, you have our dollars cleaned up, and it being 10%, that can bankrupt the county.
Do you think you would ever get those dollars back out of private hands
Yeah.
when it goes to default?
Whether it's bonding or financial assurance, I think it's the way it's written. But I am skeptical about government holding that money for the cleanup myself. That doesn't mean I'm right.
So moving forward, do we have any further discussion about all of this? Do we have an agreement? Well, of course, I know we do, Wes. I should
I've
just
got
ask
an
that question.
additional question. I've got an additional question.
So just a second, I think, I really agree with, I mean, there's been several people that have said that we need to continue the discussion.
Yes.
So I just really would like to see us maybe, I don't know how often we want to do this, I know we're all really busy. But I would like to suggest that we do this at least a minimum of every quarter. I don't know if we can do it any oftener than that, or if there's a suggestion, for oftener.
So I have a thought, and it's the thought that just came forward, is you guys have several different questions. Prioritize what's the number one priority for our legal counsel to review.
Right.
Is it financial assurance, is it bonding, what is it? I'm not trying to lead you guys to go with whatever. Work with Darwin, get at least some of the questions answered today through Darwin and through our legal counsel. We set up a meeting, but I'd like for you guys to prioritize what's your highest priority. Because we've talked a lot of different things, good discussions, a lot of different things, but what's the number one priority for you guys to be able to make decisions at your level? Have Darwin bring that to legal counsel will talk to us, Darwin will talk with us, and then sort of knock them off a little bit at a time. Is that, what do you guys think? What does the planning commission think? Because we're at a shotgun approach right now.
Right.
And so sort of need to prioritize and knock them off as we can. That's what I'm
Right.
thinking. What do the boards think?
So if we direct Darwin, or request rather than direct, Darwin to, go to Jim Bailey for some of these, to, get some information for some of these questions, and we get some answers, what is the best approach to share that information with you all?
So I guess what I'm trying to avoid is 3 different commissioners and Darwin going to legal counsel and legal counsel getting confused on what we're all asking, is for you guys to prioritize.
Right.
Get that question, and then we come back and we sit down. If we need legal counsel to set with that meeting, whether by phone or in person, then we need to do that. But I'm willing to do it sooner than quarterly.
Okay.
Because of,
So when we get information, we'll do it again.
Mm-hmm. Is there any thought on forming a separate committee where a commissioner could sit on it with you and then we?
Well, that's what I was asking
Yeah, that's what,
previously, true,
that's
yes.
what I was bringing it back to, because I know you guys have brought that up.
My thought is we've got a junior enough board of commissioners and planning commission that it might be a good idea for it to stay here, like Mark suggested, that this be the committee.
Okay. Yep.
I know I wanna be on it, and you guys do not wanna be involved in this, I don't really know, if we want a subcommittee.
Good till December.
Okay. Any more discussion? Wes, you said you had another question?
Well, it was furthering the discussion around a graduated fee schedule. It maybe needs to happen at your next meeting when you talk about that. But my thoughts being, we approve CUPs that are everywhere from a 600 acre or 320 acre, excuse me, solar project. Better not get bigger than that anytime soon.
January 1st.
That literally disturbs the entire 320 acres to a non-farm dwelling that would disturb less than a quarter of an acre. And that disturbance level, and yet they're paying basically the same fee. And I wonder if it ought to be graduated based on disturbance level. We have mines, we've had gravel pits, that we've approved that all have different levels of disturbances on the land. If some of those that are gonna cause more disturbance, If that would be a higher fee, I don't, that's my thought.
Okay.
Less than easy.
I think that's a good discussion. I think recommendation to Darwin to us on fee schedule is very appropriate, very appropriate.
I like that idea.
Okay,
Darwin, what's the fee when it's 321 acres at the state level?
And her base application was 400,000. And they have 35,000 is what they would pay if approved every year after year after year. And I'm not sure if the inflation's added into that.
That goes to the state.
Yeah,
They have
so,
1 acre
That's what I'm
difference.
saying.
So I think you guys are giving away the goose, big time.
yeah, and so is every other county. And
great.
it's just-
I don't disagree
We have
with
to
that.
justify how, all our other fees are extremely low. I mean, you can ask a goal change or a map change and it's only $1,000. And, I've been around planning, well, 13 years and most Eastern Oregon counties kept it low so that they could see some development and they didn't want to hinder development by, making their fees too large.
Until that's a water board. I mean, I look at,
Yeah, I
applying for
know,
water
yeah.
rights and water rights, it's graduated. You want more water rights, you pay more. I mean, it doesn't matter if it's one application or not.
Is it under?
We do it by the acre.
Pay by the volume.
Is it under?
so,
We just have to do that.
Yeah, I like the idea of figuring out what it is, and there was one county, when I asked all the planners this, one county was so high, they charged by the solar panel, and the few of us planners laughed, because it was like, well, you're talking millions of dollars, you never need a planning budget again, you can make everything else free after that.
What are they hanging over here? They're hanging 3,000 panels a day
Yeah.
on this project. on the
So
other side.
you're selling off land use.
Yeah, see, here's.
So if you get enough money, you allow anything come in.
Yeah,
That's the other side of it.
show us the money. You
Yeah,
want approval?
yeah.
That's
Marion
So
County on the valley side. is
321 acres, now we get $400,000, so now it's okay to have solar.
That's what happens at the state level, I think the county.
That's not what,
That's not why
that's not where I want to go or where we need to
Right.
go.
That's not what I'm trying to
But,
say.
but it's a billing for the
Yeah.
money side of it.
Yeah.
On the fee schedule, whenever Darwin brought it, is, for the most part, is based around the amount of staff time, the amount of time that was going into it. Our fee schedule was based around that type of thing, not to become making money off of just permit fees. It was the amount of time that goes in and that stuff. That's what a lot of it was based on. Correct, Darwin, that's the reason why we raised it when we did. I think Melanie was just thinking that our next chance, our time on our 18 months is July, is our next time that we can do that.
18 months from July.
18 months from July, I'm sorry. I
So
didn't hear you
legal
right.
counsel could probably, I'm always confused about that, it's from the last time you changed it, so I haven't changed this fee schedule since 2000, the board hasn't since 2014, so 18 months window to change it has long passed, so I know you guys put them on a schedule to maybe 18 months,
Planning,
but
So,
we didn't do it on this.
Yeah.
right, so my question is,
I think if you do
if
it.
it falls under ordinance 52, is that all encompassing? Or since this is a subsection, can we just do your section?
Yeah, I think you can just do my section, because it hasn't been, you can't change by law
You-
within 18 months, so, but mine has been way past 18 months, my section.
So I'm not sure you're correct on that, because we could be having fee hearings all the
Yeah, you
time.
could.
We do it,
You try to block it.
if I'm not mistaken, it's every 18 months, and if you don't change your fees within that time period, you have to wait the next 18 months. Now, there is a,
You can add new
you
fees.
can add new fees,
Yeah.
which are, you have a fee schedule already set there. If you're adding that brand new fee, you can do that less than 18 months. But let's get that determination for sure from legal counsel.
And typically, it's those bigger projects like a mine or a solar project that take up more of our time. So I think there's a reason. I mean, it's not.
Right.
so I'm just gonna jump out here and say, it sounds to me like there's agreement that we want to, this group needs to come together again, and we've got some things for Darwin to check out with legal counsel. And so when we come back, we'll have those things. So it's about 10 minutes of 6 right now, and I'm just gonna suggest that we take a break and come back to do our business with CUP,
Your
an application that we've got.
commission, yeah.
Right, for a regular.
Okay.
So I don't know that we need to adjourn this, we just need to take a break, is that
You
correct?
guys just need to recess, we need to adjourn.
We need to adjourn.
Okay,
So, nothing further to come before us. The Board of Commissioners will adjourn at 11 minutes till 6. Tomorrow we are in Silver Lake. You'll be doing on your own, sir?
Yeah, possibly.
Delegating